boy, oh boy, oh boy, we are starting off hot today. First, let me introduce myself. Reintroduce myself to others. I'm Ernest Bethea, the last outlaw. I want to welcome you all to the drama-free true crime destination. Welcome to the Summer of Justice 2024. Welcome one and all to Bethea'S Byte Reloaded. Last week, I sat right in this very spot and I declared that the summer of 2024 would be a summer of justice. Over this past week, we have gotten off to a hot start. How hot? Let me get through our missing persons report, then we'll talk about just how hot. Alright, let's go there right now with our missing persons update. Pay attention to your screen, ladies and gentlemen. This is Shanice Harris. Shanice Harris is missing out of one second. I got the wrong thing in front of me. Oh, okay. Guess I'm gonna have to work with my screen then. Okay, no problem. Shanice Harris has been missing since May 29th, 2017, out of Rock Hill, New York. She's about 38 years of age, born February 2nd, 1986. She has brown hair and brown eyes, and at the time of her disappearance, she stood approximately 5 feet 8 inches tall and weighed approximately 260 pounds. She has a tattoo on her right forehead that reads Sparks with a Z, and a tattoo on her left arm of hands folded in prayer that reads Rest in Peace. Shanice Harris was last seen in Rock Hill, New York, in Sullivan County on May 29th, 2017, and she hasn't been heard from since. She was known to frequent the areas in Middletown and Monticello, New York. The FBI is offering a reward of up to $10,000 for information leading to an arrest in the case. If anyone has any information on the whereabouts of Shanice Harris or what may have happened to her, do not hesitate. Harris, or what may have happened to her. Do not hesitate. Harris, or what may have happened to her. Oh my goodness! I didn't mute my other tab. Okay, all right. Um, Please again, do not hesitate if you have any information on Shanice Harris or her whereabouts or what may have happened to her. You're asked to call 911. You're asked to call the FBI's toll-free tip line at 1-800-225-5324. 1-800-CALL-FBI. You're also asked to call the FBI's New York field office at area code 212-384-1000. 212-384-1000. Again, there's a $10,000 reward for any information leading to an arrest in this case. You're at, if you see something and you know something about Shanice's case, please say something. That way we can do something. Let's bring Shanice Harris home safe. All right. Now, like I said, we're off to a hot start on the summer of justice. How hot are we talking? Let's just say I already have. I'm bringing some breaking news as we speak. The jury decided to deliberate one more day, and they have come to a unanimous agreement on the punishment for Chad Daybell. So I'm going to bring this to you right now, and let's go to the courtroom so I can recap before we can recap everything.
Okay, we are back on the record on CR 2221-1623, continuing the special sentencing proceeding. The jury has returned its special verdict. The court would note that pursuant to Idaho Code 18-4004, which is the punishment for murder statute in Idaho, that crime in murder of the first degree can be punished by death. And under Idaho Code 192515 subsection 7A, that states that if the jury finds that a statutory aggravating circumstance exists and no mitigating circumstances exist, which would make the imposition of the death penalty unjust, the defendant will be sentenced to death by the court. The court's reviewed the findings of the jurors in the special verdict form. They've taken their time through these deliberations to return that verdict. And so the court will proceed with sentencing first on counts 1 through 6. And again, this is an unusual hearing because the sentencing hearing's already been taking place. We've heard from the victims through impact statements and arguments from counsel. That's already taken place. In addition, a pre-sentence investigation report is not to be ordered in these hearings, so the court does not reference that. The court then orders as follows, and this will be contained in the court's judgment at the conclusion of the case. As to count 1, the conspiracy to commit first-degree murder and grand theft by deception for the murder of Tylee Ryan, upon the jury's finding of guilty and return of the special verdict form, the jury finding beyond a reasonable doubt and having returned the special verdict that the aggravating circumstances when weighed against the mitigating circumstances do not make the imposition of the death penalty unjust. The court, therefore, on count 1, the defendant is sentenced to death. On count 2, the first-degree murder of Tylee Ryan, the jury finding beyond a reasonable doubt and having returned the special verdict that the aggravating circumstances when weighed against the mitigating circumstances do not make the imposition of the death penalty unjust. The court, therefore, on count 2, sentences the defendant to death. On count 3, the conspiracy to commit first-degree murder and grand theft by deception for the murder of J.J. Vallow, the jury finding beyond a reasonable doubt and having returned the special verdict that the aggravating circumstances when weighed against the mitigating circumstances do not make the imposition of the death penalty unjust. The court, therefore, on count 3, sentences the defendant to death. On count 4, first-degree murder of J.J. Vallow, the jury finding beyond a reasonable doubt and having returned the special verdict that the aggravating circumstances when weighed against the mitigating circumstances do not make the imposition of the death penalty unjust. The court, therefore, on count 4, sentences the defendant to death. On count 5, conspiracy to commit first-degree murder of Tammy Daybell, the jury having found beyond a reasonable doubt and having returned the special verdict that the aggravating circumstances when weighed against the mitigating circumstances do not make the imposition of the death penalty unjust. The court, therefore, on count 5, sentences the defendant to death. On count 6, the first-degree murder charge, the murder of Tammy Daybell, the jury having found beyond a reasonable doubt and returned the special verdict that the aggravating circumstances when weighed against the mitigating circumstances do not make the imposition of the death penalty unjust. The court, therefore, on count 6, sentences the defendant to death. The court's next going to take up counts 7 and 9 on the insurance fraud counts. Before I do that, from the state, are there any questions regarding the court's judgment as it relates to counts 1 through 6?
No, Your Honor. Thank you.
Questions from the defense?
No, Your Honor. Thank you.
All right, moving on to insurance fraud, then the court will note that I am required to go through a sentencing proceeding on this. These are separate counts that have not been determined in the special verdict form by the jurors. Some brief procedural history. Mr. Daybell was charged by amended indictment with counts 7 and 9 insurance fraud under Idaho Code 41293, which is a felony. Mr. Daybell pled not guilty to those counts on June 9th, 2021. Thereafter, this trial was held, and as part of the findings of the jury in their verdict, they did find the defendant guilty of both of those counts. The court has considered, in lieu of a pre-sentence investigation report, the information that I've heard throughout this trial. I also heard information regarding these charges in the previous trial held last year against co-defendant Lori Vallow. I've also heard information received during the special sentencing proceeding relating to those counts as well, and have considered that information in lieu of a pre-sentence investigation report. And I'll also note the defendant waived the pre-sentence investigation report and is permitted to do that, and the court can allow that under Criminal Rule 32A. At this time then, before I move forward with the sentencing on counts 7 and 9, I will inquire of the state, is the state wishing to make any sentencing recommendation as it relates to count 7 or 9?
And Your Honor, just for clarification, were the insurance frauds count 8 and 9?
As listed in the amended indictment, they are listed as count 7 and count 9.
Okay. Thank you. Co-counsel just clarified for me on that. Your Honor, the state is prepared to make a statement. First, I would indicate for the record that in relation to the sentencing hearing, the sentencing portion handled yesterday, the state did make our best attempts to reach out to all statutory victims to allow them the opportunity to be heard by the court. And those that the court heard from yesterday were the ones that had wished to make impact statements. While not directly related to the insurance fraud, I did just want to make a clear record of that. In relation to the insurance fraud charges, in light of the sentence that has been imposed by this court and by the recommendation of the jury in relation to the other charges, the state would indicate we think that the victim statements covered everything the state could say. While the insurance charges again are attenuated to it, we've lost 3 individuals that the state can do nothing to bring them back. And so the best we can do is move forward in seeking justice on their behalves. In relation to the insurance counts themselves, given the sentences, we would recommend this court impose jail time and have that, or prison time, impose a sentence and run it concurrent with the imposition of the other sentence by this court. I believe they carry up to 15 years in prison. We'd recommend they run concurrent with each other and with the imposition of death in this case. We would also recommend restitution in the amount of $130,000 to LifeMap and $300,000 to Primerica. As part of that, we would also recommend a waiver of any fines or court costs in this matter in order to allow restitution to be paid if any money is available to go towards that.
All right, thank you for the state's sentencing recommendations. Mr. Pryor, does the defense wish to make sentencing recommendations as to, I'll do them collectively, counts 7 and 9, the insurance fraud counts?
No, Judge, there's nothing further. Thank you, Your Honor.
All right, is there any objection to the requested restitution amounts of $130,000 and $300,000?
Judge, we may need to set that out at this point, but I'll let the court know if that changes.
All right, I'll permit 30 days for the scheduling of a contested hearing on restitution. If that becomes an issue, we could conduct that hearing most likely remotely on a Zoom hearing if it becomes an issue. At this time, I will ask, because I need to on these counts, before I impose any sentence, Mr. Daybell, you do have the right of allocution, which permits you to make a statement on your own behalf in any mitigation of these offenses. Is there any statement you would like to make before I proceed with sentencing on those counts?
No.
Very well. The court then, having considered the information previously referenced, finds that pursuant to Idaho Code 41293, which under subsection 4 indicates a penalty of up to 15 years of prison. On each of those 2 counts, the court is going to impose a prison sentence of 15 years. So a 15-year sentence will be imposed on count 7 the court will take under advisement the issue of restitution requested by the state. The court will not impose any fines. The court also will impose a 15-year prison sentence on count 9. Also pursuant to the same statute, take under advisement the issue of restitution. The court will note in imposing these prison sentences that I have reviewed Idaho Code 192521, which requires me to go through certain criteria about the imposition of a prison sentence versus a possibility of parole or a lesser sentence. And I would note that the rationale for the prison sentences is that these are intertwined with the murder charges for which the death penalty has been imposed on those counts. And when the court looks at the sentencing factors under 1925-21, I would note in mitigation that Mr. Daybell has been incarcerated an extensively long time in local jail and has a previous law-abiding history, and I have considered that. I've also considered that he's always conducted himself respectfully, from what I've heard from all of the jailers that have ever interacted with him over the years that he's been incarcerated for these charges. However, the court finds under Idaho Code 2521 also that any lesser sentence would depreciate the seriousness of these offenses because this life insurance was obtained based on the murders of individuals and procuring life insurance payouts unlawfully. And because of that, it's the most serious offense, that circumstance that could lead to that. In addition, imprisonment will provide an appropriate punishment and deterrent for the defendant and others, and will also be a deterrent for the community as well. So the court having then concluded with the sentencing on that, I will not order any fines because the defendant's previously been deemed indigent and has received the death penalty on these murder counts, and find it would be futile to have an order of fines in the case. So with those remarks, then the court typically would address the defendant further, but in the special sentencing proceeding, the victim impact statements and the evidence has already demonstrated on the record, I think, the seriousness of what's occurred, and I don't find any reason to further delve into the court's rationale other than what was listed in the statute. So unless there's anything further, that will conclude the sentencing, but I will address the post-conviction issues that need to be addressed at this time. Does the state have anything further then on the sentence and count 7 and count 9?
No, Your Honor. Thank you.
Anything further from the defense?
No, Your Honor. Thank you.
Okay. Mr. Daybell, in this case, given the sentence that was imposed in counts 1 through 6, there's a special appellate and post-conviction procedure for capital cases, and an automatic stay may be in effect. There's a statute that's Idaho Code 192719 that sets out certain deadlines. I am providing you and counsel with a courtesy copy of that statute, but I will note a few of the deadlines that are listed in there. Under subsection 1, when the punishment of death is imposed, the time for filing an appeal shall begin to run when the death warrant is filed. Number 2, the death warrant shall not be filed until 42 days after the judgment imposing the death sentence has been filed. Number 3, within 42 days of the filing of the judgment imposing the punishment of death, the defendant must file any legal or factual challenges to the sentence of conviction. There's other important and critical deadlines that are contained within that statute, and I am going to provide a copy of that to Mr. Pryor to ensure that the defense is well advised of those post-conviction rights that would apply in this special proceeding. I'll also note that there's an additional rule, Idaho Criminal Rule. She'll give me a moment. I think it's 44.2. Rule 44.2, and that's the mandatory appointment of counsel for post-conviction review after imposition of the death penalty. That rule is also applicable in your case, and a copy of the rule itself is going to be provided to you and counsel to ensure that you're well aware of any post-conviction rights you may have. With that, then, the court is going to conclude the special sentencing proceeding. Is there anything further I need to take up from the state?
No, Your Honor. Thank you.
Anything further from the defense?
No, Your Honor. Thank you.
Okay, thank you everyone for your abiding by the court's courtroom conduct order. We'll be in recess.
Ladies and gentlemen, there you have it. Chad Guy Daybell, convicted of murdering his first wife, Tammy, and convicted of murdering his second wife's children, JJ and Tylee, now sentenced to death. So-called Doomsday Prophet has been sentenced to death after being convicted on charges that he killed his first wife and the two youngest children of his second wife. Chad Daybell was convicted of conspiracy and first-degree murder in the 2019 death of Tammy Daybell, convicted of those same charges in the deaths of 7-year-old JJ Vallow and 16-year-old Tylee Ryan, children of Lori Vallow. Daybell was also convicted of 1 count of grand theft and 2 counts of insurance fraud. On June 1st, today, the jury recommended the death penalty for Daybell. The judge agreed with their death penalty recommendation and sentenced Daybell to an additional 15 years for each insurance fraud conviction. Last year, a jury convicted Lori Vallow on conspiracy and first-degree murder charges in the deaths of her children and conspiracy to commit murder in the death of Tammy Daybell. She was sentenced to 3 consecutive life sentences without parole. An indictment accused the couple of espousing religious beliefs to justify the murders. The remains of Vallow's children were found on Daybell's property in June 2020, 9 months after they were seen alive. By then, Vallow was sitting in an Idaho jail on charges stemming from the children's disappearance. She was arrested in Hawaii in February 2020, where she and Daybell had relocated amid a cloud of suspicion. Now, before we even get off the hook on that, what I'm gonna do is share the one piece of video you may not have seen already. Ready? I'm gonna hide this and I'm gonna share another tab once I can get it open. Okay, great. All right. For those of you who missed out on the verdict, here is that.
All right, the court's going to next just make a reference that there is a courtroom conduct order in effect in this proceeding to remain in effect. So I appreciate everyone complying with that order, as most of you have done throughout the proceedings in this case. At this time, then, the first matter I'd like to take up is to do a roll call of the jury for the record. So, Madam Clerk, if you could please conduct a roll call of our jury to make sure they're all present and properly seated at this time.
Juror number 1, red card number 27. Juror number 2, red card number 219. Juror number 4, red card number 631. Juror number 5, red card number 653. Juror number 7, red card number 752. Juror number 8, red card 1680. Juror number 9, red card number 823.
Here.
Juror number 10, red card 1358.
Present.
Juror number 11, red card 1365. Juror number 12, red card 716. Juror number 14, red card 997.
Present.
And juror number 15, red card 1078.
All right. Thank you, Madam Clerk, for conducting the roll call. All right, at this time, I'm next going to inquire from the jury foreperson. Has the jury reached a verdict? All right, thank you. Mr. Bailiff, if you would please retrieve the verdict from the jury foreperson. Thank you. But the court has reviewed the verdict form. I'll note that all counts have been properly marked, as well as the verdict forms have been properly dated and signed by the foreperson. The next step then is Mr. Daybell, if you and counsel would please rise. I'm going to have the clerk read the verdict.
In the District Court of the 7th Judicial District of the State of Idaho and in for the County of Fremont. State of Idaho Plaintiff versus Chad Guy Daybell Defendant, case number CR 22211623. Verdict. We, the jury, duly impaneled and sworn to try the above entitled action for our verdict, unanimously answer the questions submitted to us as follows. Question number 1. In regards to count 1 of the amended indictment, is Chad Guy Daybell not guilty or guilty of conspiracy to commit first-degree murder of Tylee Ryan and grand theft by deception? Guilty. Question number 2. In regards to count 2 of the amended indictment, is Chad Guy Daybell not guilty or guilty of first-degree murder of Tylee Ryan? Guilty. Question number 3. In regards to count 3 of the amended indictment, is Chad Guy Daybell not guilty or guilty of conspiracy to commit first-degree murder of Joshua Jackson Vallow and grand theft by deception? Guilty. Question number 4. In regards to count 4 of the amended indictment, is Chad Guy Daybell not guilty or guilty of first-degree murder of Joshua Jackson Vallow? Guilty. Question number 5. In regards to count 5 of the amended indictment, is Chad Guy Daybell not guilty or guilty of conspiracy to commit first-degree murder of Tamara Tammy Daybell? Guilty. Question number 6. In regards to count 6 of the amended indictment, is Chad Guy Daybell not guilty or guilty of first-degree murder of Tamara Tammy Daybell? Guilty. Question number 7. In regards to count 7 of the amended indictment, is Chad Guy Daybell not guilty or guilty of insurance fraud? Guilty. Question number 8. In regards to count 8 of the amended indictment, in regards to count 9 of the amended indictment, is Chad Guy Daybell not guilty or guilty of insurance fraud? Guilty. Dated this 30th day of May, 2024, and signed by the presiding juror.
All right, Madam Clerk, thank you for reading the verdict. At this time, I'm just going to collectively ask the jurors, all of you, is this in fact your unanimous verdict on each of those counts? Very well. At this time, I'm going to inquire if the parties wish to have the jury polled. Does the state wish to have the jury polled?
No, Your Honor. Thank you.
Does the defense, Mr. Pryor, wish to have the jury polled?
No, Your Honor. Thank you.
And between that verdict on the verdict on Thursday, the jury recommendation today, and the immediate sentencing, Chad Guy Daybell, his days are pretty much done. His wife is spending 3 consecutive life sentences behind bars, and Chad Guy Daybell is on his way to death row. All I can say to that is, may God have mercy on his soul. All right, next up, let's see, what am I working with next? Oh, we got the TikTok star murder trial verdict. Ooh, if I can find that real quick. Okay, let's start there. All right. There we go. All right. Okay, ladies and gentlemen, this is the verdict about to be handed down in California versus Ali Abulaban in the deaths of his wife and his best friend.
Welcome back to Closing Arguments. I'm Julia Janae in for Vinnie Politan tonight, who is out shooting the new season of Accomplice to Murder. It has been a monumental day in courtrooms across the country. We have been watching jurors deliberating in several high-profile cases that are nearing their end. In California, a jury has come back and decided the fate of former TikTok star turned double murderer Ali Abulaban. And in New Jersey, Christopher Gregor, a man accused of abusing his 6-year-old son to death, also awaits a life-altering decision from the jury. And finally, in New York City, we have updates involving a third group of jurors, this one deliberating the fate of the former President Donald Trump. As we continue to cover the final moments of these big-time cases, be sure to keep it right here on Court TV. And we're going to begin this hour over on the West Coast, where a jury made their decision in the double murder committed by Ali Abulaban. Now, he already admitted to fatally shooting his estranged wife and the man that she was romantically linked to at the time, a man that Abulaban testified he was at one time a close friend of. He claimed that the killings were a crime of passion, committed in the moment, heat of passion, but the state claimed that these murders were premeditated and planned out by Abulaban beforehand. So let's go back into that courtroom, rewind it, and listen to the jury handing down Abulaban's fate.
In the Superior Court of the State of California in and for the County of San Diego, the people of the State of California, plaintiff versus Ali Nasser Abulaban, defendant, case number SCD 292181, verdict. We, the jury in the above entitled cause, find the defendant, Ali Nasser Abulaban, guilty of the crime of murder in the first degree of Rayburn Cardenas.
Silence. Nothing.
Of Rayburn Cardenas Baron, in violation of Penal Code Section 187, Parent A, as charged in count 2 of the information. And we further find the allegation that in the commission and attempted commission of the above offense, the defendant, Ali Nasser Abulaban, intentionally and personally discharged a firearm, to wit, a handgun, and proximately caused great bodily injury and death to a person within the meaning of Penal Code Section 12022.53, Parent D, to be true. Special circumstance as to count 1 and 2, and we further find the allegation against the defendant, Ali Nasser Abulaban, that he has in this proceeding been convicted of more than one offense of murder in the first or second degree within the meaning of Penal Code Section 190.2, Parent A, Parent 3, to be true. Dated May 29th, 2024, jury 4-person. Same title, same cause, verdict. We, the jury in the above entitled cause, find the defendant, Ali Nasser Abulaban, guilty of the crime of murder in the first degree of Anna Abulaban in violation of Penal Code Section 187, Parent A, as charged in count 1 of the information. And we further find the allegation that in the commission and attempted commission of the above offense, the defendant, Ali Nasser Abulaban, intentionally and personally discharged a firearm, to wit, a handgun, and proximately caused great bodily injury and death to a person within the meaning of Penal Code Section 12022.53, Parent D, to be true. Special circumstance as to count 1 and 2, and we further find the allegation against the defendant, Ali Nasser Abulaban, that he has in this proceeding been convicted of more than one offense of murder in the first or second degree within the meaning of Penal Code Section 190.2, Parent A, Parent 3, to be true. Dated May 28th, 2024, jury 4-person.
But like they say in a lot of good infomercials, but wait, there's more. Or I want to go back to that point in the courtroom when the first guilty verdict was handed down. And I want you all to pay attention to the cheers that erupted in the courtroom.
In the Superior Court of the State of California, in and for the County of San Diego, the people of the State of California, plaintiff versus Ali Nasser Abulaban, defendant, case number SCD 292181, verdict. We, the jury in the above entitled cause, find the defendant, Ali Nasser Abulaban, guilty of the crime of murder in the first degree of Rayburn Cardenas.
Silence. Nothing.
Of Rayburn Cardenas Baron in violation of Penal Code Section 187, Parent A, as charged in oh, it is. Okay.
Right there, and I apologize for the audio. That's on them, not on me. But still, you heard it loud enough to hear the cheers after the first guilty verdict was handed down. I believe if I had to put my own 2 cents on this, his own testimony did him in. And I mean, come on. He went on the witness stand. He unraveled in front of his own counsel, in front of the state, in front of the jury, the judge, everybody within earshot of him. And then on top of that, through tears, he said, "I'm shooting and I can't stop." I'm shooting and I can't stop. Ladies and gentlemen, this is all on Ali Abulaban. So we just have to wait to see what the sentencing will be like for his case. But right now, Ali Abulaban found guilty in the murders of his wife Anna and his friend Ray. Next up, let me see what I got here. I did the TikTok star. That's done. I've done Chad Daybell. Now let's go to about the treadmill abuse murder trial. The state of New Jersey, versus Christopher Gregor. Okay, we're gonna take you right back to the courtroom. This time we're going to Connecticut. Excuse me. I'm hot today. Okay, let me try this again. We're going back to court, but this time we're going to New Jersey. I'm gonna take you back into the courtroom for the verdict in the treadmill abuse murder trial against Christopher Gregor, who's accused of abusing and eventually causing the death of 6-year-old Corey Misiculo, if I'm pronouncing the name correctly. I'll find out in a little bit. Right now, let's take you back to the
President, 12 deliberating jurors are back in the jury box. In addition, we have our alternates seated in the jury box to prevent them from appearing on camera. So those are seats 4 and 11. In addition, seats 3 and 13 are empty as those jurors have been excused. Madam Foreperson, would you please rise? Madam Foreperson, has the jury reached verdict?
It has, sir.
And is that verdict unanimous?
Yes.
Ma'am, I'm going to read to you each count. Please give me the jury's unanimous response. 1, how do you find as to count 1, endangering the welfare of a child?
Guilty.
2, how do you find as to count 2, murder?
Not guilty.
3, how do you find as to the charge of aggravated manslaughter?
Guilty.
And you did not answer question 4?
No, sir.
At this time, thank you, Madam Foreperson, you can be seated. At this time, I'm going to poll the jury. Members of the jury, you've heard the verdict as read by your foreperson. At this point, I'm going to ask each juror by number, except the 2 alternates, to respond yes if the verdict read by the foreperson is your verdict, no if the verdict read by the foreperson is not your verdict. Juror number 2.
Yes.
Juror number 3 is empty. Juror number 4 is alternate. Juror number 5.
Yes.
Juror number 6.
Yes.
Juror number 7.
Yes.
Juror number 8.
Yes.
Juror number 9.
Yes.
Juror number 10.
Yes.
Juror number 11 is an alternate. Juror number 12.
Yes.
Juror number 13 has been excused. Juror number 14.
Yes.
Juror number 15.
Yes.
Juror number 16. Is counsel satisfied that the verdict is unanimous?
Yes.
At this time, I would ask the clerk to record and note in the minutes that the verdict is unanimous. Ladies and gentlemen of the jury, the function you have performed is one of the most important civic duties you can ever be called upon to fulfill. With the return of your verdict, your service in this case is complete. Upon your discharge, you are not required, except upon court order, to discuss your deliberations or verdict with anyone. Additionally, no attorney or party or any person acting on their behalf is permitted under our rules of court to examine you or question you or even to discuss with you your verdict or your deliberations or your role in this matter. In some states, judges are actually able to stay afterwards and speak to the jurors about the experience. In New Jersey, judges and attorneys are specifically prohibited from doing that. If anyone approaches you associated with the case, the attorneys or the parties, please notify me immediately. It's possible you may be contacted by others, including members of the media. As you know, obviously we had media coverage in this trial. It will be up to each of you to decide whether or not to speak to those persons or entities about your service as a juror. If you agree to be interviewed, you may discuss whatever you want in whatever manner you deem appropriate. However, I'd ask you to keep these things in mind. The key to your function as jurors has been the free discussion amongst yourselves during deliberations, and the privacy of those deliberations is essential to the continuation of the fair administration of justice. All jurors have the prerogative to keep confidential their communications with their fellow jurors during deliberations. In fact, it is in the public interest that there be the utmost freedom of discussion in the jury room, and that each of you be permitted to express your views without concern for public reaction or criticism. Under no circumstances should you make a statement to the media or anyone else that you would not be willing to repeat under oath in court in the presence of your fellow jurors. But on a personal note, I want to thank you for your service. I know we told you in the beginning that it's a civic duty, but this case was a long case. It was difficult scheduling issues, and it was a difficult case with a lot of emotion. I told you we had the best justice system in the world, and one of the reasons, probably the principal reason, is because our Constitution guarantees a right to a trial by jury, and we can't do this without you. It's truly remarkable witnessing this reality and your participation in it. It's not only been my pleasure to have you here, it's been my privilege to have you here. I'm going to give you one final instruction, and I'm sure the attorneys join in that, by the way, our thanks and our appreciation for your attention and also how you've gotten along as a group. But I'm going to give you one final instruction, and that is the Sheriff's Department is going to escort you out that door, out a separate private entrance to the courthouse. I don't want to risk that somebody who's upset one way or the other comes up to you. They're going to make sure there's plenty of officers taken to your cars. So if you want to exchange some telephone numbers or something like that, if you become friends, I ask you to do that quickly, because I would really appreciate that you get in your vehicles and you go home and get out of here in the event there's any reaction by anyone. So again, thank you so much for your service. Just hand Corporal Bennett your jury pass on the way out and the verdict sheet. And been my pleasure, ladies and gentlemen. Thank you so much.
I would ask everybody in the gallery to please remain in the courtroom until the jurors have left.
And that's it. That's it for Christopher Gregor. New Jersey father found guilty of aggravated manslaughter in the death of his 6-year-old son, who prosecutors argued died from injuries sustained from chronic abuse. 32-year-old Gregor was charged with murder in the death of Corey Misiolo. There it is. That's the right pronunciation. Misiolo. However, the jury found him guilty of the lesser-included offense of aggravated manslaughter. He was also found guilty of endangering the welfare of a child. His sentencing was scheduled for August 2nd, where he's facing up to 40 years in prison. Surveillance footage from a fitness center at Gregor's apartment complex presented at trial shows Corey Misiolo running on a treadmill as his father increases the speed on March 20th, 2021. In the video, the boy stumbles and falls multiple times as he attempts to keep up. Gregor can be seen grabbing Corey by the shirt, and at one point, he appeared to bite the child's head, according to prosecutors. 2 weeks later, on April 2nd, Gregor said he brought his son to a hospital after the boy woke up from a nap stumbling, slurring his words, and experiencing nausea and shortness of breath. Corey was taken for a CT scan where he began having seizures. Life-saving measures were taken, but Corey could not be saved. It's never good. It's never good to abuse a child. But in this matter, it makes it even worse. Which is why the jury came back. The jury could have easily came back with a murder conviction, but apparently the evidence didn't support it. So the lesser included charge of aggravated manslaughter was deemed a little more appropriate. So Now we wait for August 2nd for Gregor's sentencing. Next up on this red hot start to the summer of justice, Michelle Troconis. Michelle Troconis, she was sentenced in the missing mom conspiracy trial. Hold please. There we go. Okay, this video will be brief, but it's gonna give us in Michelle Troconis' case.
From what the court has heard, she has a great deal to offer. Court has no control over what her decisions will be. Her life is hers. The following sentences are going to run concurrently. On the count charging conspiracy to commit murder, 20 years execution suspended after 14 and a half years to serve, 5 years probation. Tampering with physical evidence, 5 years execution suspended after 4 years, 5 years probation. Conspiracy to tamper with physical evidence, 5 years execution suspended after 4 years, 5 years probation. The second count of tampering with physical evidence, 5 years execution suspended after 4 years, 5 years probation. Hindering prosecution, 5 years execution suspended after 4 years probation. After 4 years, rather, 5 years probation. Total effective sentence, 20 years, execution suspended after 14 and 1/2 years, 5 years probation. You will have an opportunity to challenge every finding that the jury made and every ruling that the court made.
As you heard, the judge sentenced a woman convicted of helping her boyfriend murder his estranged wife to 20 years in prison. In March, Michelle Troconis was convicted of conspiracy to commit murder, tampering with or fabricating physical evidence, and hindering prosecution in the murder of Jennifer Dulos, whose body has never been found. May 31st, a judge sentenced Troconis to 20 years behind bars, with eligibility for parole coming after 14 and a half years. After she is released, she will be under probation for 5 years. Jennifer Dulos, a mother of 5, was reported missing on May 24, 2019, and police investigating her case immediately noticed blood evidence in her home. Her vehicle was found abandoned on a road near a park. Nobody was inside it, but the running lights were left on and the vehicle's transmission was in reverse. Blood spatter was noted on the passenger side of the vehicle. In court documents, investigators said that the evidence showed that Jennifer's estranged husband, Fotis Dulos, went to Jennifer's home after she dropped the children off in the morning and then killed her, tied her in zip ties, and put her into her own vehicle and attempted to clean the scene before driving away with the body. While Jennifer's body has never been found, a probate judge formally declared her dead in 2023, according to multiple reports. So, Troconis has 14 and a half years before she's eligible for parole. And if she is granted it after which time, she'll be on probation for the next 5 years. Justice served? Maybe. But even though she's formally declared dead, Jennifer Doulos' body still hasn't been recovered. So now while Troconis will sit behind bars for the next 14 and a half years, Jennifer Doulos still has yet to be recovered. Next up, we're going to go to North Carolina. We're going to go to North Carolina. We're going to talk about Christopher Palmiter. If I can catch that one, we're going to go to North Carolina. We're going to go to him. This is the case of missing Madalena Kojikari. Now, when I first had this set up, he had testified that he did not know where his stepdaughter was. So let's go to that testimony right now.
Going to return to the stand for day 2 of direct examination in our next hour here. On Tuesday, Christopher Palmiter took the stand in his own defense. He's on trial for not reporting his 11-year-old stepdaughter, Madalena Kojikari, missing back in 2022. The 62-year-old stated he didn't harm her, nor does he know where she is. But the defendant did describe spiritual activities performed by his wife, Diana Kojikari, prior to her daughter's disappearance.
There were certain rituals that she would do. She always said she was fighting demons, and I know this. The example is from Elizabeth Clare Prophet, because I watched it. They would take a sharp knife and they would cut the imaginary strings that demons had around you.
What do we think of the credibility of this defendant, Christopher Palmiter? Here to discuss it, Josh Schiffer, Jack Rice, and look at we brought in Franz. So this truly is a panel of experts. Franz Borchardt is with us. Franz, to you first. What'd you think of the defendant on the stand? And we talked about it yesterday. We're like, I bet he blames the wife, the mom. Sure enough, he throws that little doozy out to the jurors that she was into some weird spiritual stuff. Thoughts?
I picture a bus, and his foot is on the pedal, and he is snow plowed right over her, pun intended. And look, that's the right defense for him. That is the right defense for him. This is a weird case, Ted. This is a weird case because, look, at the end of the day, our paternal instincts are, why wouldn't you do something, right? Why wouldn't you do something if your child just went missing for a period of time? Does that mean that they have enough dots to connect to get to the finish line that is a conviction? I don't know. But I will say that bus has definitely left some tread marks on his co-defendant.
Jack, the prosecutors obviously believe that these two know exactly what happened. Otherwise, they wouldn't be here with this lesser charge of just not reporting. And this one is 18 months is the max. They're doing this to buy time, correct? I mean, they think there's more afoot here.
Oh, no question about it. And Franz is absolutely correct. I mean, let's think about this for a second. It's not just what a witness says in the box. It's about how they behave. It's about how you would expect them to behave. And if you look at this man, if you look at what he looks like, how he appears, his lack of emotion, how just sort of flat he is, all of those things, those don't necessarily show guilt, but they feel like it. And the thing is juries have to read the tea leaves, and some of this is science, some of this isn't. Some of this is all visceral gut. And when you look at this man and you look at his behavior, it just doesn't fit. That's going to be something that grabs a jury, and they will hold on to it.
Madalena is still missing, Josh. If you're an investigator and you see this guy talking about, now he's kind of attacking the wife, do you get him under some bright lights, try to lighten up those raccoon eyes of his and say, dude, where's the body, and why don't you throw her all the way under and tell us what happened? Because he seems to be going that way.
Well, and that's exactly what investigators are trained to do, is to take those golden nuggets of blame and waffling and misdirection when you're interviewing someone, chase them down, logically test them. Reality testing is what we call it a lot of times, where when someone's being interviewed, you take their logic to the full end and show them in their own words how what they're telling you just can't work. And the state's prepared for the empty chair defense, the bus driver defense, the octopus headlock defense, whatever you want to call it. They're ready for this because it was so telegraphed at the front end. And like you said, Ted, this is all about squeezing for information and buying time.
Here is the defendant on the stand talking about caring for his missing stepdaughter.
A lot of my attention was on Madalena. Her mother seemed to be doing her prayers a lot, and Madalena would always ask me to play with her. I never turned her down. So take her for bike rides, walk to the neighborhood, take her to the park. And Donna was usually the one that had me take her to the park. I played all kinds of games with her.
Franz, you watch that, you just want to grab the dude and say, all right, well, then where is she? What happened? Because we know you were there.
So maybe I'm dead inside. Maybe. I come to the same place, which is, if you're going to sit on the stand and cry crocodile tears at this point, what were you doing then? And then tell us what happened. I mean, it's like there's that gorilla in the room where we all believe that he knows, and he's just not going that extra distance of telling us what happened, which makes him look horrible. He really may have nothing to do with this, but it looks horrible, and candidly, his emotional state on the stand now just seems totally disingenuous.
Yeah, Jack, I mean, come up with a story. If you're going after the ex, like, all right, well, give us some more, or give the investigators more, because he's writing that strange line that satisfies nothing, and not his case either, right? I mean, it's really frustrating.
I think about my time working for the CIA doing interrogations. And honestly, this was part of the training. And part of the training is this, is you give people what they want and what they need in order for them to talk to you. You have to think about what it is that this man wants. What's driving him? Is the idea of saying, okay, it wasn't you, it was all her. You were completely in the clear, and therefore she was the one completely to blame. Fine, let's give him that. Let's give him the feeling of power that he wants. Let's give him the feeling of strength, of super invincibility. Whatever it is you need to do to put him in the space where he finally just bellies up. The problem is at least at this point, the police didn't figure that out. The interrogators didn't figure out what it is that makes him tick, that can drive him to actually do and say what it is that they need from him. And so sometimes when you're doing an interrogation like this, you have to think about it like that. It's not about what you want, it's about what they need. Give it to them so they can turn around and give you what you want. That's the difference.
Josh, today, direct continues, and then it's time for the hard part, the cross. What would you do if you were prosecuting? I know you really don't have that hat. You've got lots of hats and glasses, but let's say you had one of those prosecutor hats. How would you attack a guy like this who seems a bit numb?
Well, you hang them out to dry, and you use their own words in the uncomfortable power of silence. Because one of the great powers you have in trial is the ability to direct everyone's attention at a specific point, juncture, or location. and that includes very specifically the witness. And you can drop very short, very clear, virtually unanswerable questions on a witness like this, that their response, we've already seen his evasion. We've already seen how he just won't say what we all know he knows. And by doing that, you show that shadow of guilt that builds and builds and builds and just crashes over him and is going to bury him because he doesn't have enough there to justify the acquittal with what the state's bringing.
All right, we'll see that play out later today. He'll be back on the stand, finishing up direct and then cross-examination. We'll see if he cracks or even shows some emotion as he continues on the stand.
Now that's when his direct examinations just got started. We're far beyond that now. This is the verdict in his case.
Folks, we have breaking news in another case that Court TV has been covering, the missing stepdaughter trial in North Carolina. The jury has now reached a verdict.
As foreperson of the jury, you have returned as unanimous verdict of the jury in case number 22 CR 366223 that you find the defendant, Christopher James Palmiter, guilty of failure to report disappearance of a child to law enforcement. Was this your verdict?
Yes.
Ladies and gentlemen, jury, please stand. Your foreperson has reported that you found the defendant, Christopher James Palmiter, in 22 CR 366223, guilty of failure to report disappearance of a child to law enforcement. Was this your verdict? So say all of you? Yes. You may be seated.
As you heard, the jury found Christopher Palmiter guilty of failing to report 11-year-old Madalena Kojakari missing. Now, she was last seen in December of 2022. Palmiter took the stand in his own defense, saying he didn't harm his stepdaughter and does not know where she is, but he was not charged with those crimes. He was only charged with not reporting her missing. It took 3 weeks for he and his wife to report her missing. Diana Kojakari, the child's mother, pleaded guilty earlier this month on the same charge. She was sentenced with time served, she was in jail about 17 months. And Madalena still has not been found.
Yeah, so basically we're still on the lookout for little Madalena Kojakari. And as I always say, if you have any information on her whereabouts, please don't hesitate. Let me get the information. I'll find a missing persons flyer for Madalena Kojakari, or better yet, maybe I still have have the FBI Okay, let me see. There we go. All right. Okay, here's all the information I'm giving you guys. This is on Madalena Kojakari. She was born April 11, 2011. She has brown hair, brown eyes. At the time of her disappearance, she stood about 4 feet 10 inches tall, weighed around 90 pounds. She was last seen on surveillance video getting off her school bus outside her home in Cornelius, North Carolina on November 21st, 2022, and has not been seen since. She was reported missing to her school on December 15th, 2022. Parents reported last seeing her on November 23rd, 2022. Madalena was last seen wearing jeans, pink, purple, and white Adidas shoes, and a white t-shirt and jacket. Again, if you have any information regarding the disappearance of Madalena Kojikari or her whereabouts, please do not hesitate. You're asked to call 911. You're asked to call the FBI's toll-free tip line at 1-800-CALL FBI, 1-800-225-5324, or you're asked to call the Cornelius Police Department. That number is 704-892-7773, 704-892-7773. Or you can submit your tip anonymously online at tips.fbi.org. But I plead with you, as I always do. Any information you can give regarding the whereabouts of Madalena Kojikari will be a great difference maker in bringing her home safe and sound. Remember, as I always say, if you see something, please say something. That way we can do something. We can do all we can to bring Madalena Kojikari home safe and sound. All right. Now let's move onward and upward. Oh. I kind of say the worst one for last. I think I kind of say the worst one for last. The hush money trial. The state of New York versus Donald John Trump, the 45th President of the United States. Now, I'm going to tell you guys right now, first of all, I've hung up my political hat. So, I'm not saying this as a Democrat. I'm not saying this as a Republican or whatever. Political party has nothing to do with this. This is about justice. There's no rigging. It's all about the evidence presented to a jury of his peers, and them coming to a unanimous verdict, which is what we're bringing to you here. So, whatever your political affiliation is, that's on you. If you side with Trump, again, that's on you. But this is the verdict. Period. Let's go right to the courtroom now, and let's hear that.
Hello, and welcome back to Court TV Live. I'm Michael Ayala. As you know, we're monitoring a number of trials today here on Court TV. Well, the latest breaking news is that a verdict was rendered in the case involving former President Donald Trump. He was found guilty on all charges. He was facing 34 different counts relating to election fraud, tax falsifying of business records, tax fraud, and a number of other charges. I will say this, there are a number of options for the judge as far as sentencing is concerned. There is jail time on the table. Not sure if that'll happen in this case. The possibility of house arrest is on the table as well as probation. We do know that he is the presumptive Republican elected for president. So the judge is going to have to take that into account if he wants to hit the campaign trail. So we'll continue to follow that case. We'll get that to you in just a minute. Right now, where are we going? We're going to Karen Swift. All right, let me bring in Michael Jafer very quickly. Michael, I want to get your reaction to that verdict there in New York. Donald Trump found guilty of all charges.
Completely unprecedented. What do we do now? Is he going to stay out on bond? Is he going to be sentenced to jail? If he's eventually sentenced to jail, which jail is on the table, do you take the Secret Service into jail with him? Because he can't be in general population. So I'm flabbergasted. This is unprecedented. I'm going to be glued to the TV. I want to see what happens. But yeah, this is completely unprecedented. I have no idea what this judge is going to do.
Now, Mike, I will say this. He violated the gag order in the case, I think 9 times, 8 or 9 times. And the judge, on a number of occasions, said, look, if you don't stop, I'm going to throw you to jail. And he kept saying, I don't want to do that. He eventually, of course, didn't do that. I don't think he wants to send someone like Donald Trump to jail. Again, we do know there are a number of political implications as far as that goes. And as I said, there are options: house arrest, probation. This is the type of case where that may be very much appropriate. So those could be possibilities.
Even though the judge cannot consider what's beneficial for the broad population society, he's going to have to in this case, because if you put house arrest, for example, that you can't campaign 5 months out of a presidential election, some people saying the most important presidential election in their lifetime, right? So house arrest means he can't campaign. So the half of the country that really believes that this is a conspiracy is going to be now even more emboldened. So all of this is on this judge's shoulders. This judge, in addition to getting death threats and people harassing it outside, there's a scene outside of the courthouse, right? So it's going to be very, very, very challenging for this judge to concoct some sort of a now he's got to sentence him. What does he do?
Yeah, that's a big question. Folks, if you're just joining us, we just learned moments ago that former President Donald Trump was found guilty on all charges in his historic hush money trial going on in New York. And again, the question is, what happens next? Of course, jail time is on the table. House arrest, probation are also on the table for the former president. But again, also he's, again, the presumptive elector or presumptive nominee for president for the Republican Party. So that has to, again, be taken into account. This morning, when they did the readback, really they asked for it yesterday. In my experience here at Court TV, whenever there's a readback, Michael, shortly thereafter, the jury delivers a verdict, because really what they have is a question that needs to be answered, and generally that readback will answer that question. They go in, discuss it, and then have a verdict. It seems like that might have been what happened.
I think that's exactly what happened. I was very puzzled by the fact that the judge did not give them a copy of the jury instructions. They just went into the box, and he read the jury instructions, and they remember. Even I can't remember the jury instructions. I have to circle back to them. So you are right. When they do a readback, usually the verdict comes right after that, because they're trying to clarify an actual legal point. These are not professionals, right? These are people who are doing a civic duty, and they're sitting on a jury. This is the only time they've done it in their lives. And so when they ask for a readback, usually it's because they're trying to overcome. There's 2 or 3 jurors in the box. They're trying to overcome a specific issue. They debate, they need it read back, and then they make a decision.
Yeah. I thought this might have been a referendum on the testimony of Michael Cohen. But as you know, in a case like this, you can't convict on accomplice testimony. So just on his testimony, you couldn't convict. What he said in court was enough to convict, which is why I thought the Pecker testimony, the gentleman who ran or was in charge of the editorial for National Enquirer, his testimony was so important because it corroborated, at least to some extent, Michael Cohen's testimony. And that's why when they asked for that readback, I thought it might have been a done deal.
I think so. I agree, because when Michael Cohen was testifying, right, this is a person who had direct knowledge. He had the most intimate type of professional relationship you could have with the defendant as their attorney. I don't recall the last time an attorney was testifying against his former client. And I'm sure it's happened, but when that happens, you go numb. You get goosebumps because, oh my God, you tell everything to your attorney, right? But then the corroboration by the National Enquirer witness, that pretty much sealed it. I have my opinions, but in hindsight, it looks like you're right. That's what happened.
Yeah, and you know, Michael Cohen was the shadowy, shady character, right? We all know that. And there was a question as to whether this jury would even believe him. The prosecution, you know, had to call him. And you're a trial attorney, so you know this. When you're dealing with these type of shady and shadowy situations, you got to deal with shady and shadowy characters. Yeah. And I think maybe the jury took that into account.
Most attorneys, some of the most successful ones, had theater majors, right? I don't know what his undergraduate, but you're an actor. You're in an arena, and he knew exactly how to act. And again, he had first-hand knowledge. This was my client, and he abused me. He made me go out and fix stuff for him, right? And we all have watched Breaking Bad and Better Call Saul. That's who this guy is. He's the Better Call Saul guy.
Yeah, the guy who's willing to do just about anything, right? Because you can use your law degree in many, many ways. Yeah. I was told that by a mentor very early on, and you're going to choose the path that's most right. That's what he used to say to me. You know, at the end of the day, they needed to find that he aided and abetted in this conspiracy, right? The idea that he wanted to block the election or block someone from attaining office. That was a violation of the New York election law at the end of the day. Do you think they got there with this? Because not only, a lot of people thought the problem with the prosecution's case was they couldn't prove that he actually knew what was going on, or he, had someone do it, or aided and abetted someone, or encouraged someone to do this.
Donald Trump was standing on very solid legal ground, right? He could come back and say, this is my attorney. I trusted him to know better and to know what to do and what not to do. I believed in him. I had a deep relationship with him. And so I believed that he was doing things according to the law. I'm not an attorney. And so I believe he stood on solid legal ground in his defense, right? But at the end of the day, you're this wealthy billionaire. You hire a young attorney and you pay him gobs of money. He looks up to you. You're running for president. The jury must have believed that Donald Trump was the person in control and Michael Cohen had no intelligence, no intellect, was just doing. So to me, that's why it was difficult. I didn't get there because there was an attorney as a buffer. If there was a banker and you were instructing your banker to make these payments, easier case at that point.
Yeah. If you're just joining us, folks, once again, just moments ago, all right, actually, I think we have a live shot of the president talking outside of the courthouse right now. So let's go out there live.
You have a so respect, DA, and the whole thing. We didn't do a thing wrong. I'm a very innocent man, and it's okay. I'm fighting for our country. I'm fighting for our Constitution. Our whole country is being rigged right now. This was done by the Biden administration in order to wound or hurt an opponent, a political opponent, and I think it's just a disgrace. And we'll keep fighting. We'll fight till the end and we'll win because our country's gone to hell. We don't have the same country anymore. We have a divided mess. We're a nation in decline, serious decline. Millions and millions of people pouring into our country right now from prisons and from mental institutions, terrorists. And they're taking over our country. We have a country that's in big trouble. But this was a rigged decision right from day one, with a conflicted judge who should have never been allowed to try this case, never. And we will fight for our Constitution. This is long from over. Thank you very much.
Why should others vote for convicted felons?
Are you going to drop out?
You believe the rule of law? You trust the jury?
All right, so that was Donald Trump reacting to the verdict today as he was found guilty on all charges by a New York City jury. And again, he called himself an innocent man. He's done that throughout, even as far as the allegations within the trial of having these affairs with other women. The whole country is rigged, is something he said, and pointed to the trial perhaps being rigged, and that we will keep fighting. Michael J.
Again, ladies and gentlemen, this is something that Donald Trump has a tendency to do. Even when he's won, in 2016 he wins the election, but it was rigged against him. This trial, it was rigged against him, except for the fact that they had all the evidence right before a jury. Oh, but the judge was against him. The system was against him. This was against him. That was against him. Do you know how many defendants could make that very same claim? This is a direct message. This is a direct message. If any ordinary Joe will go into a courtroom as a defendant, and that a jury of his or her peers can look at the evidence and say yes, this person is guilty. My question is this: we still haven't gotten a sentencing yet. What makes Donald Trump so special? Sure, he is the 45th president of the United States, but still, what makes him so special? We're all subject to the law, the laws of the land. If you're caught, you're gonna be arrested. If you're arrested, you're gonna be brought to trial. If you're gonna be brought to trial, there's only two ways that can go, and there are 12 people, or one, if you decide to go this route, that can decide your fate. That's the 12 jury members in the box, or the judge. Donald Trump, you didn't decide to have a bench trial, you decided to have a jury trial. So your claim that the judge was rigged against you, irrelevant. The judge didn't make that decision. The 12 people in that jury box did. And they decided you, unlike your claims, they decided that you were guilty 34 times over. And that's not a political statement, that's a legal statement. All right. So those are the 6 cases in which, those are the 6 cases that kick-started, and I mean kick-started, our summer of justice. I thought it was gonna. I thought this was gonna be a short, quiet week because of the fact that the courts were closed on Monday for Memorial Day. Surprise, surprise. Let's go right in, and let's go to our first story of the week. NFL kicker Brandon McManus. He's accused of sexually assaulting 2 women. The Washington Commanders said on Monday that they were made aware of a lawsuit filed in civil court last week against kicker Brandon McManus, and the Jacksonville Jaguars acknowledged that they are also being sued. A Commanders spokesperson said the team is looking into the situation and has spoken with McManus' agent and the NFL office, saying that we take allegations of this nature very seriously. ESPN reported 2 women are suing McManus for sexually assaulting them during a charter flight to London last year when he was playing for the Jaguars, who said they are aware of the complaint and the significance of the claims being made. As we look into the matter, it bears emphasizing that we insist on an organization built by people who represent our community and game with the highest character and class. That's what the Jacksonville Jaguars in a statement. Citing court documents that have not yet been posted on Duval County's public records database, ESPN reports the women identified as Jane Doe 1 and Jane Doe 2 are accusing McManus of rubbing and grinding against them during the flight, and the Jaguars of failing to supervise him and create a safe environment for staff serving the team. They are seeking more than $1 million and asking for a jury trial. Again, that's according to the worldwide leader in sports, ESPN. McManus' lawyer called them absolutely fictitious and demonstrably false allegations. We intend to aggressively defend Brandon's rights and integrity and clear his name by showing what these claims truly are, an extortion attempt. That's according to Brett R. Galloway of McLaughlin and Stern in a statement to the Associated Press. McManus, who turns 33 next month in July, signed with the Washington Commanders in March. The Philadelphia native has been in the league for a decade, the first 9 seasons with the Denver Broncos after playing at Temple University. Brandon McManus, we don't hear his name much because, well, given the fact that he's a kicker, number one. Number two, His name is not that big in the league. So I'd say this. If these allegations are true, then these ladies, Jane Doe 1 and Jane Doe 2, then yes, they had every right. They have every right to sue. They had every right to seek these damages. But I'm gonna leave this up to you guys. I'm gonna leave this hanging right here with you. What if they're not being truthful? What if they are just looking for an easy payday, simply because this guy has played for the NFL for 10 years? I'll let you think about that. You drop me a comment in the comments section, or in the community tab. I'll be sure to post this edition. I'll be sure to link this edition of the Byte in the community tab too. Karen Swift murder trial is still going onward. I covered Madalena Kojikari's stepfather testifying, the subsequent verdict. All right, here's somebody I know right now is breathing a sigh of relief. The world's #1 golfer, Scottie Scheffler, word is now his charges are dropped against him and an arrest outside of the PGA Championship. Let's go to Court TV and breaking news.
We have some breaking news out of Louisville, Kentucky. In the case against pro golfer Scottie Scheffler, prosecutors announced today that all charges against him have been dropped. Scheffler was arrested earlier this month in Kentucky on his way to a PGA championship. He was facing several charges, including second-degree assault on a police officer after driving around a police barricade. Scheffler says he misunderstood the officer's commands and feared for his safety after the officer hit him with a flashlight. Both sides reportedly agreed not to pursue any legal action. But again, all charges against pro golfer Scottie Scheffler have been dropped in connection with the incident that took place earlier this month. We'll continue to monitor this story and bring you any updates as we get them.
And when they get him, you can bet Bethea'S Byte Reloaded will get it too. All right, let's move on. Let's move onward. Scott Peterson. A judge has granted Scott Peterson and his request to retest the duct tape. All right, let's go to that one.
Mr. Peterson has been waiting 20 years to find some of these police reports and audio recordings and video recordings that should have been provided.
New developments in the Scott Peterson case that could be tipping the scales in his bid for a new trial, and not the way he was hoping.
Mr. Peterson, could I have you please just raise your hand if you can both still see it here to you? Okay, and Mr. Peterson is raised his hand, acknowledging that either have him on mute because of the background noise he's still able to hear. All counsel who identified the people in Mr. Peterson are present.
All right, a little tough to hear there. Judge Hill, though, in San Mateo County. Scott Peterson was appearing via Zoom yesterday in a hearing, and at the end of the day, the judge said no to a request from the LA Innocence Project representing Scott Peterson to test. They wanted 14 items to test, including a swab from the van that they believed that could have Laci Peterson's DNA on it. At the end of the day, the judge said no to all of the items except for one, and that is a piece of duct tape that was recovered from Laci Peterson's pants during her autopsy. That will get tested. There was an initial test back in 2003. It came back as a positive for, they had DNA, but they couldn't at the time zero in on it. It was too small of a sample. The testing technology of today will be able to help them maybe zero in on that. And who knows, at the end of the day, it could be Scott Peterson's DNA on there or someone else. We'll see. But the long and the short of this is this was a massive blow to Scott Peterson and his bid for a new trial. Let's talk about it. Bring in our guest still with us, criminal defense attorney and former prosecutor Michael J. Brown, and in studio, criminal defense attorney Eric Johnson II. Eric, to you first on this. The LA Innocence Project, they say, listen, we looked at this case, we think that there's a there, we want to test all these items, and one of the most important ones from their filing was this burned out orange van that was found about a mile away, and at the time there was a mattress with a blood stain in it. They wanted access to the preserved evidence, and the judge at the end of the day said no yesterday because it had been tested in 2019, and the testing was basically, it came back, if there was DNA, it was a male's DNA. So your thoughts on the judge's rule? I mean, someone from the outside might say, well, why just let them test it? You know, if you think you got your guy. Why would the judge say no?
Well, one of the reasons in the roles of a judge is to maintain order in the courtroom itself. If the judge felt that this would be duplicative of something that happened before and would not necessarily advance the case or provide the information to assist Mr. Peterson's defense, then the judge would be well within his authority to be like, no, we're not going to waste the court's time and test this information.
And if, yeah, there has to be precedent, Michael J. Brown, in that if every defendant willy-nilly from saying, I want to retest everything from my trial, it would overload the system. This is a high-profile case, though, and what are your thoughts in terms of the judge's ruling and the state's argument, which was valid? They said, listen, this was tested. This was tested as late as 2019. So the judge agreed.
Yeah, Ted, you need finality. That's what trials are about. You have your trial. It's finality for the prosecution, for the witnesses, for the victims' families, for the defendant. And you have the appellate process, and they went through it, and it's final. It's done. Having said that, though, obviously when there's the possibility that this guy could be innocent and there is some type of new evidence that's come forward, you want to give them the benefit of the doubt, but you have to make a showing. So I know that you're looking at it as, well, they were denied on the 14 items, but it's significant in that one piece. This tape on the victim's pen is going to be tested. That's significant. It's new testing, much more modern technology than 20 years ago. And you never know what that can reveal. And you take that as a foundation if it's beneficial for the defense, and then go forward with more testing on more items.
Good point. So it isn't over necessarily. That could be a little window for them. You have this duct tape that was on Laci's body, and if, let's say, it comes up with some random person,
correct,
that starts a whole nother chain, does it not, for the defense to explore and find that person and see if there's any connection.
Well, then you have to take the DNA from that person that was identified, and then they would want to compare that to the other items that were received in this case to see if that person matches up on some of those other items as well. It would open up basically a big thing for the defense if somebody was able to be identified, that they would have the ability to open it up and see if there's somebody else that could possibly be identified as well outside of their client.
The LA Innocence Project, which is different than the National Innocence Project, the Barry Scheck started organization, they've taken this case. Michael, they looked at all of it. It took them about 6 months to pull the trigger and announce publicly that, yeah, we're going to dive in head first and try to exonerate this person who we think was wrongly convicted. How important for Peterson, because he, to your point, has already exhausted his appeals and he's off death row, so he doesn't get the free legal help that a death row inmate gets by state law. How big a deal is this for Scott Peterson to have an organization like this? You say what you will about the organization. These are competent attorneys on his side.
Oh, it's a big deal, Ted, because you have folks who are so experienced in these types of cases and the scientific evidence, and they'll have experts at their beck and call. They'll have many attorneys who have gone through this and know exactly the points they have to hit on. Again, I understand that they did not win their entire motion, but I really think it could be significant if it reveals some positive evidence for them, and that's we'll have to wait and see. And it could show Scott Peterson and game over at that point.
No, yeah, if it's his DNA on the tape, it's over. Final word, Eric. Is this still a long shot, is it not, for Scott Peterson to get a new trial?
As was just stated by my esteemed colleague, what happens is if something else comes up that exonerates him or introduces the identity of somebody else, that's great for him. If it comes back as his DNA or anything that can be attributed to him, as he stated, it's game over.
Game over indeed. We will continue to monitor that. There's another hearing July 15th on a post-trial discovery motion. The LA Innocence Project asking for more information. This is not going away just because of the ruling. Michael J. Brown, thank you so much for your time. Really appreciate it. Enjoy the rest of your day as we round out this week. Eric Johnson, great to see you. Thanks for coming in.
So for Scott Peterson, the fight continues to prove his innocence and either get a brand new trial or be totally set free. We'll keep you updated. Let's see what's next. Becky Hill. I bring Becky Hill's name because of another name you may remember, Alex Murdaugh. Yep. Well, Becky Hill's been charged with ethics violations. The clerk of court who served during the Alex Murdaugh murder trial and was accused of communicating improperly with the jury has been summoned to appear at a hearing to answer charges from the State Ethics Commission. Hill was thrust into the national spotlight first during the historic trial for the former attorney convicted of murdering his wife and son, and then again when Murdaugh's attorneys filed an appeal accusing her of making inappropriate comments to the jury. The motion was denied after an evidentiary hearing at which Hill testified. While the judge found that Hill's comments didn't rise to the level of meriting a new trial, two other allegations of ethical wrongdoing have led the State Ethics Commission to formally file 76 charges of ethics violations against her. Court TV reviewed the complaints and submitted to the Ethics Commission, which accused Hill of using her position and authority as Colleton County Clerk of Courts to promote her book, give unauthorized people access to secure areas, and misappropriate thousands of dollars. A photograph of Alex Murdaugh reading a book in the courthouse holding cell, allegedly taken moments before the jury returned its verdict, was allegedly taken from a secure feed in the public and media have no access to. The photo was shared online by photographer Melissa Gordon, who was later hired to work on Hill's book, which was co-written by her husband, Neil Gordon. According to one complaint, Hill was also earning extra money by offering people tours of the courthouse and even allowing them to take photos sitting inside the same cell. In a statement to Court TV, Neil said, "My wife Melissa and I spoke to the Ethics Commission investigators for several hours about our business relationship with Becky. They were very interested in the picture she texted us of Alex Murdaugh in his jail cell. Melissa and I both signed affidavits that we received the photo from Becky Hill, but she did not instruct us to place the photo on social media or in the book." End quote. A second complaint, filed by Laura Hayes, a former deputy clerk in Colleton County, accused Hill of taking thousands of dollars in bonuses illegally. Hayes wrote in her complaint, quote, "I asked her one time if it was ethical for her to write herself a bonus check, and she said, 'It's federal money, right?' And I said I didn't want to go to jail for unethical behavior. And she said she heard federal prison is pretty comfy." End quote. Ethics investigators say Hill gave herself $9,880 in bonuses from an account meant for employees who work on child support cases. Hayes said that Hill gave false information to the finance department for multiple employees about how much they worked on child support for the bonuses. Hill is also accused of improperly reimbursing herself thousands of dollars for gifts and lunches for courthouse staff, listed as things like Easter goodies, Mother's Day gifts, and a birthday party where the supplies included Smirnoff Ice. The Ethics Commission is holding a hearing on the allegations against Hill on December 19th at their offices in Columbia, South Carolina. Becky Hill, the bottom line for you is simply this. It wasn't your money to tamper with. It wasn't your money to touch. So that's one reason why the Ethics Committee is breathing down your neck. Everything you do is even if you're writing a book, it's got to be above board. If it's not, you're gonna get hung up for it, and that's exactly what's happening here with you. We'll see what happens on the 19th. Next up, we have an actor accused of stabbing a Hollywood makeup artist arrested in Texas. Prosecutors say 34-year-old Nick Pasquale broke into Ali Shearhorn's home on May 23rd and stabbed her over 20 times. Shearhorn, a famous Hollywood makeup artist, had recently filed a restraining order against Pasquale, according to a press release. Shearhorn was hospitalized with critical injuries, prosecutors said, and according to a GoFundMe campaign created for Shearhorn, she is making positive steps in her recovery. Pasquale is facing multiple charges, including attempted murder. He is facing life in prison if convicted as charged. Pasquale appeared in the 2023 film Rebel Moon and the TV show How I Met Your Mother, according to IMDb. Shearhorn's credits include Rebel Moon, Babylon, and the 2024 film Mean Girls. Now, if it's that bad, I always say when they're together and things go bad, that whether it's boyfriend, girlfriend, husband, wife, whatever, separate. Go as far away as you can. Shearhorn seems to have done all the right things. Only difference was Pasquale was just, for lack of a better word, obsessed. That being the case, then Pasquale is going to end up doing life behind bars for nearly killing this woman. We'll see what happens when this thing goes to trial. Daybell, Trump. We got an update on Kohlberger. Surveillance video under scrutiny. All right, let's go right to let's see, on the docket. This sounds like one from Vinnie Politan, so let's go right to him. Oh, maybe not. Yeah. This sounds like Vinnie Politan. Let's go to him right now.
In your experience with working with AT&T records, is it common or uncommon to have two warrants, one that relies on the content of the first and that's the same day?
It's not uncommon to see a small time period that produces results that would increase the desire, the need for a bigger time period of records. Seeing that entire process happen twice in the same day is extremely rare.
That was Cy Ray, a geolocation analyst who testified in today's hearing for the case against Brian Kohberger. Kohberger is charged with the murders of 4 University of Idaho students. They were found stabbed to death in their off-campus home in November of 2022. Their names are Xana Kernodle, Ethan Chapin, Kaylee Gonzalez, and Madison Mogan. Now, Ray delivered testimony about gaps in the data surrounding Kohberger's movements the night of the murders. And if you recall, Kohberger submitted an alibi claiming he was out driving the night of the stabbings. He maintains that he was enjoying stargazing on a long drive late at night when he was unable to sleep. Court TV anchor Vinnie Politan has more for us on Brian Kohberger's official alibi.
The alibi for the accused Idaho student's killer is that while 4 college students were murdered in the early morning hours, he was out for an innocent joyride. Defense attorneys called their client an avid runner and hiker, claiming he often took drives in the countryside late at night and in the early morning hours to enjoy the moon and stars. The accused killer's filing says that once school started, his hiking decreased and his drives increased. His attorneys plan to present cell phone data and photos of the night sky that show he was in the countryside on several occasions. The defense says their client's cell phone was south of Pullman, Washington, and west of Moscow, Idaho on November 13th, 2022. So they say the car captured on video along the Moscow-Pullman highway near Floyd's cannabis shop could not be his. Floyd's cannabis shop is off State Route 270, the main route into Moscow from Pullman, Washington. His alibi does not confirm or deny that other surveillance videos of the white Elantra in Moscow is him. Here's the state's timeline of the accused killer's movements, outlined in their probable cause affidavit. Prosecutors say his phone pings in Pullman, Washington at 2:42 a.m. at his Washington State University campus apartment. His phone is on the move at 2:44 a.m. A few minutes later, his cell phone stops pinging. Investigators say that could be because the accused killer turned it off. And for the next 2 hours, investigators track his alleged movements using only surveillance video of what they say is his white Elantra. The state alleges that the accused killer drove from the WSU campus to Moscow by way of State Route 270, a claim they support with surveillance of a white Elantra seen heading in the direction of the highway at 2:53 a.m. and a photo of the same car near Floyd's cannabis shop further down the highway. The accused killer claims that it was not him. Cameras caught a white Elantra traveling through Moscow, first on streets near the crime scene, then on the victim's street from 3:39 a.m. to 4:20 a.m. Police say the accused killer turned his phone back on at about 4:48 a.m. near Blaine, Idaho, a rural community in the countryside about 10 to 15 minutes south of Moscow. According to the prosecution, from 4:50 a.m. to 5:26 a.m., his phone travels south towards Genesee, Idaho, going west toward Uniontown, Washington, a route that could lead toward Hawaii Park. The accused killer claims that park was his favorite place and that in the early morning hours of November 13th, he drove there. His alibi does not say when he got home, but the state says at 5:30 a.m. his cell phone uses service in Pullman, Washington. According to prosecutors, that's when he got home, not after an innocent drive, but after committing a quadruple murder.
And as we look ahead to one of the most highly anticipated murder trials, the trial date set to begin in this case in early March of next year, March 3rd, 2025. For now, let's bring back in our think tank to talk about this case. We've been talking about it for months, turning into years now. Still with us, Eklund Mercy, Kirk Nurmi, and Nima Rahmani. Nima, this alibi, if the Floyd's cannabis shop evidence that he was there, if that can be definitively debunked, does that equal reasonable doubt in this case?
I don't think so. There's plenty of evidence here. There's a single source DNA at the scene. There's apparently DMs with the victims that may show some sort of stalking, him actually showing up at the place of business. And even if the phone was turned off on airplane mode and didn't hit the cell sites the night of the murder, it was there the very next day and plenty of times before the murder. So I think there's enough. We have a fuzzy eyewitness account as well. And look, these types of pretrial motions are normal. The defense has to provide some notice of their alibi defense. The judge is going to let it in because it would be so prejudicial not to. This is the defendant's only real defense in the case and what might keep him off death row. And as far as the other pretrial matters that were heard today, the genetic genealogy and the gag order, it's really all sort of par for the course. I know everyone's frustrated. It's taken a long time, but we know that these pretrial motions are to tee up these issues for appeal if and when Kohberger is convicted and sentenced to death.
It can feel like it's taking a long time. And Kirk, we thought at one point it was going to be the summer of 2025. Now it's going to be spring or earlier, March 3rd, 2025. And you've got students who are going to have to take the stand. Students who are still in school, or if they're not in school, they're still going to have to travel back here to testify in probably the most horrific part of their life, their most horrific memory. Your thoughts on the timing of this trial?
You know, death penalty cases take a long time because they're going to be looked at 10 to 15 years down the road. If Mr. Kohberger is sentenced to death, which I think is likely in this case, I agree with Nima in terms of the likelihood of conviction as well as a sentence of death, that's going to be looked at for 10 to 15 years down the road. And one of the things that they're going to be looking at is the effectiveness of the counsel he had at the trial level. That means the counsel, whether they believe their client, whether they believe Mr. Kohberger's alibi, he was stargazing, what have you, because they really have no direct evidence to dispute it, they have to pursue all this cell phone data, all the DNA data with vigor because they have to move forward. They cannot just ignore what Mr. Kohberger says when it is his life at stake. So all these things have to be pursued, and that's what takes a long time, along with the mitigation case, right? Preparing that alongside of contesting guilt, you have to prepare for that mitigation case, which by its nature takes a long time.
Eklund, this stargazing alibi, do you think the defense went a little bit too far? I know the prosecution had demanded more specifics for their alibi, but they put specific places like that park, which the park on its website says that they close before dark and would not have let anyone in as far as a gate in that area. So if he's saying he was there in the wee hours of the morning, would make it pretty difficult. Do you think the defense may have given too much information that can then be debunked as well?
No, I think that they're trying to do the my cousin Vinny type of defense that, you know, it could be another Elantra. The issue is that they're really trying to force the prosecution's hand in proving their burden. And just the fact that he looks scary, and coupled with the fact that he was around that area, coupled with the fact that he just so happens to have a major in criminal defense, although it sounds like a slam dunk isn't enough for the murders. So I think juries now are way more sophisticated. We're gonna have to see, is there a room in his home that has all four students with little, you know, with little connections to them? Is there like a doll of one of the victims? Do we have a safe, you know, do we have storage that has, like, you know, pictures and love letters? They're really going to have to lock in So it's not going to be as simple. I don't think that it's going to be that simple. I think that juries now are way more sophisticated. And although this crime is terrible, they're going to have to provide more. Putting the burden on the defense is not going to work here.
And we will see how things unfold, and we can expect some more pretrial hearings many times over before we get to that March 5th trial date.
Sorry about that. I had to step away from the computer a minute. So, with all that surveillance footage, Kohlberg may have a somewhat decent alibi, but that remains to be seen. For now, we know that his next court date will come in 2025. Let's see, Mom. Oh, let me go ahead and get this one straight, but before I bring it to you, this next story, it is a must that I throw up the trigger warning. Because as I read it, yes, and I did have time to read it all, this one is as gruesome as it sounds. Okay. According to police, a brother dismembered his pregnant sister and left parts on the front step. A Minnesota man is accused of brutally murdering his sister and her unborn child before dismembering the body. 23-year-old Jack Joseph Ball is facing 2 counts of second-degree murder for the deaths of his sister Bethany Ann Israel, age 30, and her unborn child. At the time of her death, Israel was 17 or 18 weeks pregnant. According to documents obtained by Court TV, the victim's mother called police just after 11 p.m. on May 23rd, saying that her daughter had gone to have dinner with her brother at a home in Lakeville, but failed to return home. When the mother went to the residence to investigate, she told police she saw Ball and he just tore out the house. When she approached the residence, she saw blood and feared for her daughter's life. When police arrived, they found a large pool of blood on the kitchen floor and on the cabinets. They also found a bloody saw, a hatchet, and large knives covered in blood. While looking through the home, they also found several dismembered body parts belonging to Israel. Police began to search the area and surrounding communities for Ball, and while doing so, received another 911 call from a resident who saw the suspect placing what appeared to be a body part on their front step. Police confirmed that there was a body part left outside the home and found Ball nearby, covered in blood. Investigators also found other body parts near the property. Dakota County Attorney Kathy Keenan said, "The allegations in this case are deeply disturbing and horrific. Words can't describe what our law enforcement partners encountered during the investigation. My office will work hard to ensure the victims receive justice and will provide the necessary support for the victim's family." Quote end quote. While Ball was suffering what was believed to be a self-inflicted wound to his neck, he was able to clearly communicate with officers and accurately tell them the date, time, and name of the current president. Ball was taken to the hospital to be treated and appeared via video conference in court, where his bail was set for $2 million without conditions. $1 million with conditions. Investigators who searched Ball's belongings found journals and handwritten papers in which he allegedly wrote that he was angry with the victim because she was pregnant and no longer innocent. An online fundraiser created in Israel's name describes her as a cherished wife, daughter, sister, and an expectant mother, as well as a beloved figure in the volleyball community. Ball is scheduled to appear in court on June 10th. Maybe it's me, guys. Maybe it's me, but I think this brother, wanted to have relations with his sister before anybody else got to her, and he's upset because not only it couldn't happen, it didn't happen, and he decided like most bad relationships when they end, if I can't have her, nobody can. That's not the best way to go about things, and this is what's gonna be his downfall. We'll see what happens on June 10th when we get updates on this case. And finally, this in this very short, this is a shorter edition of Bethea'S Byte Reloaded than normal, but I'm gonna briefly take you to Julia Janae, who has an update on the suspect in Lake and Rye.
We do have a quick update on the man who's accused of killing a nursing student on the University of Georgia campus. That happened earlier this year. Defendant Jose Ibarra was back in court this morning where he pleaded not guilty to killing 22-year-old Laken Riley while she was jogging back in February. This is the first time we've seen the defendant in court for this arraignment. We'll continue to bring you any updates on this case as we get them.
Okay, I'm sorry, I forgot I was muted and off the screen, but like I said Jose Ibarra, as you heard from Julia, he's accused of murdering nursing student Laken Riley, and he's entered a plea of not guilty at his arraignment on Friday. He was arrested on February 23rd for the murder of 22-year-old Riley, who was killed while jogging on the University of Georgia campus. Now listen up. Listen to everything he's accused of. The indictment charges Ibarra with 10 charges, including malice murder, 3 counts of felony murder, kidnapping with bodily injury, aggravated assault with intent to rape, aggravated battery, obstruction or hindering a person to make an emergency phone call, tampering with evidence, and peeping Tom. Riley's family members were in the courtroom Friday. As Ibarra was let in, her mother began to cry. That was according to the Atlanta Journal-Constitution. Ibarra is accused of attempting to rape Riley, asphyxiating her, and seriously disfiguring her head by striking her head multiple times with a rock. A tampering with evidence charge is for allegations he disposed of his jacket and gloves to conceal the crime. He's also accused of spying on a woman at an apartment at the UGA Village housing complex the day Riley was killed. The judge said he expects a status conference to take place in early August. And that one, ladies and gentlemen, is going to be one of the big trials that I'm looking forward to whenever it's scheduled. Now, normally this would be the end of the end portion where I would have a statement or two, maybe even 3, from Court TV's Julie Grant. Julie has had herself a busy week between hosting the Scripps National Spelling Bee and and co-hosting closing arguments yesterday with Vinnie Politan at CrimeCon in Nashville, Tennessee. I look forward to hearing from her on Monday, early Monday morning. But so for now, I guess I get the last statement. And my statement has a lot to do with the true crime community. It's been it's getting close to 2 years since I've joined a part of this. My very first cases, as you all know, is one I'm still looking forward to seeing the end of. The Boy in the Box case. I joined in because I want to see justice done right. Over these last nearly 2 years, I have watched with bated breath criminal defendant come, and I've watched and I've seen criminal defendant then they come in and catch guilty verdict after guilty verdict after guilty verdict. It was so hot. It was so hot last year. I declared a summer of justice, and what did I get? Guilty, 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 guilty. So now this summer is coming in. Last week I made that declaration. I said, you know what? I'm gonna do this. I'm gonna do this again. I believe deep down in my heart that this summer is gonna be as hot and as crazy as it was last summer. So, like I said it on last week, I, Ernest Bethea, the last outlaw, hereby declare the summer of 2024 a summer of justice. This time I won't use the horns. I made that declaration last week, not knowing that starting this past week, I would catch guilty verdicts all week long. To say I'm off to a hot start is an understatement. I mean, for a short recap of everything I just showed you. Ali Abulaban, guilty of killing his wife and his so-called friend. Christopher Gregor, guilty of aggravated manslaughter in the death of his 6-year-old son. Michelle Troconis, guilty of having her hand in the death of Jennifer Dulos. Christopher Palmiter, guilty of failing to report his stepdaughter, Madalena Kojikari, missing. Donald J. Trump, the 45th President of the United States, guilty of 34 counts of falsifying business records. And finally, the one that just wrapped up, Chad Daybell, guilty for murdering his first wife, Tammy, and the youngest children of his second wife, Lori Vallow, Tylee and JJ. And just earlier today, Daybell sentenced to death. Yes, I say again, we are off to a hot start, but then again, we're just getting started. I know there are a lot more. I know there are a lot more cases to come throughout the summer, and you can bet Bethea'S Byte Reloaded is going to be right here to cover every last one. We got two currently going on right now. Tennessee versus David Swift, Massachusetts versus Karen Reed, and there's still more to come. So get ready. We're already off to a hot start, and we're not gonna stop. I believe until either the temperatures cool down or the calendar says September. That's my statement for this week. Oh, but I do have one other announcement I do want to make. Keep your eyes peeled here, because Bethea'S Byte Reloaded is going to take you to Wisconsin to a circus. What do I mean? I'm going to take you guys to a circus. I'm going to take you back to the Waukesha Christmas Parade trial. Wisconsin versus Darrell Brooks. That's going to be my next edition of Bethea'S Byte Reloaded throwback. So get ready. We're gonna take you to a circus, and the ringmaster. I'll let you decide. Is it the defendant Darrell Brooks, or will it be the presiding judge? I'll detail all that before I begin broadcasting that. Until then, that's all I got for you for this week's edition of Bethea'S Byte Reloaded. You guys, you guys are amazing. I thank you, I thank you, I thank you, and I thank you. If you're looking to follow Bethea'S Byte Reloaded, it's on Facebook at Bethea'S Byte Reloaded. Also on YouTube under the same handle. You can follow me on X and Instagram. Now watch the differences. On X, it's EKB316 capitalized. On Instagram, EKB316 lowercase. Follow me on you can follow me on TikTok. I will have this video link there at King of Hearts 316 2021. And until June 5th, ignore the top name that's up there until then, because some knucklehead tried to hack it and didn't finish the job. Only thing he did was change the name. It's all so I'm gonna take care of that before this week is out. Also, you can follow me. You can email me at kingofhearts316_09 at outlook.com. If you happen to enjoy this wild verdict-filled edition of Bethea'S Byte Reloaded, you can be sure to tip me on PayPal at EKB316, on Cash App at $EKB316, or Venmo EB The Last Outlaw. Alright? This is the summer of justice, people, and this is true crime news without all the drama. Where your opinions matter, lively debates here are encouraged, your voice is heard, and above all else, justice served. Ladies and gentlemen, this is the spot. You want true crime, this is where you want to get it. You want true crime drama free, this is where you get it. This is the drama free true crime destination. This is Bethea'S Byte, and by God, hot summer 2024, it's reloaded. I'm Ernest Bethea, the last outlaw. Thank you so much for joining me here. Let's do this again. And in fact, I'm thinking about this and thinking. Yeah, next week, we're going to do this again. It's Saturday night's main event. Join me here, all right? Thank you again for joining me here today. Until then, you guys know what to do. Bite this. Thanks for watching and joining me here at the drama-free true crime destination. Be sure to like, share, subscribe, and drop me a comment on this video. And be sure to follow Bethea'S Byte Reloaded all over social media. This is Bethea'S Byte, and it's reloaded.